Ladies and gentlemen, as I said, jury instructions are of the utmost importance, and our guest today is an expert on the jury instructions in this particular case. His name is Jim DeSimone. He is a civil rights attorney and also wrote a fabulous article at the beginning of this case about the potential for jury instructions being so important in this case. Welcome, Jim.
Good morning, Heather. Thank you for having me.
So, Jim, I read that article with great attention. I shared it around to a lot of people because I couldn't agree with you more. The jury instructions in this case, and we had the defense asking for specific instructions and the prosecution asking for specific instructions, which happens in every case. But how important is it? Well, first of all, who did the instructions that were given in this case lean towards, and how important is that?
Well, I think it leaned towards the law. I was glad to see the jury instructions that were given by Judge Cahill because I think he stuck with the law, especially when it applied to the unreasonable use of force by the police. The defense wanted to throw in a lot of language, some which was consistent with Graham versus Connor that we heard about in the trial, which is the seminal U.S. Supreme Court case from 1989, setting forth the standard that if force is unnecessary, it's unreasonable, and you judge the actions of the police officer, not from what Derek Chauvin is subjectively feeling, but what an objective, reasonable officer would do. We heard Mr. Nelson use that reasonable police officer. Somebody said he said that word over 100 times. Yeah. But the interesting thing, as far as the trial goes, is the only reasonable police officers we heard were from the city of Minneapolis, who said that the force was excessive. So I thought the jury instructions were fair. But there is one issue that I think is a little bit tricky that I thought in rebuttal they could have done a better job on that third-degree murder charge, and that's with the second-degree murder charge that deals with intent.
Yeah.
You know, we have two competing dialogues here as to what intent does he have to have in order to be found guilty.
And that's one of the points that you made in that article at the beginning of trial, because that for many is going to be, I mean, there's two major things that we think that the jury is likely considering most. And that is whether he had the requisite intent to make this a second-degree murder case and whether Chauvin's actions were the substantial cause of the ultimate death here. And when it comes to intent, the jury instructions seem to be lying a little bit more in favor of the prosecution. Would you agree with that?
Yes and no. I mean, I definitely think so. When you look at the instructions themselves, and they just have to have the in terms of intent, he has to have the intent that the force he is using is intentional, i.e., the knee on the neck. And there's no question about that, as was really emphasized by Jerry Blakewell's excellent rebuttal argument. Look, he didn't just trip and fall on his neck. He intentionally applied that pressure. Where it gets a little tricky is in the definition, because the definition says when it defines intentionally or intentional, and it says that the defendant must have knowledge of those facts necessary to make his conduct criminal. So Eric Nelson takes that and says basically that Chauvin has to intend to commit a criminal act for you to find intent. The prosecution complains about that at break and say, look, he is misstating the law. And the judge did not give any curative instruction. He said he would allow Mr. Blakewell to deal with that on his rebuttal. And I thought he did a good job, but I thought he could have done a little bit more. Why not put up the instructions themselves?
Yes.
Again, and bring the jury back to it, put them up on the board. I mean, they're a careful jury. They're taking their time. I'm sure they're reading it. But to say, look, he had knowledge of those facts.
Yep.
He has knowledge of the facts that this guy is passing out in front of him. He has knowledge that his pulse is that he has no pulse. So, of course, he has knowledge of the facts.
Yeah. And the reason this is so important, ladies and gentlemen, is because studies have shown that in the closing, juries appreciate going through the different allegations, the different charges against the defendant, and going through them one by one. You know, sometimes this talk of the law is less exciting than the talk of the facts, but it is of vital importance in this case, and we'll continue to talk about it. All right, Jim, so there you have the prosecutor talking about the fact that this is not against the police, but against a specific police officer. Do you think that that was a good move, not only for this case, but for the global impact that this case has had and will have in the future?
I agree on both counts. I think it was, in some ways a brilliant move, in some ways just a necessary move. I mean, having prosecuted police officers in the civil sense, you do not want to disrespect police officers to the extent that you're going to turn off potential jurors. And let's face it, this jury provided a good balance. The reason why these 12 jurors were picked is because they each did provide some balance between respect of the job that police officers have to do and the respect for the sanctity of life that was at stake for George Floyd. So, and yes, we do have the broader issue here of everyone is on pins and needles, no matter which side you are on, as to what this verdict is going to mean for our country. And you hope that the verdict is fair. I mean, I think that the evidence at trial would point to a conviction on you know, I think on all counts. I think you make a case that for every single count, the
Yeah.
prosecution has proved its case. And public perception will really be important because let's face it, we all want to have a just society, a society where we can trust the police, where we can call the police when we're in danger. I thought he made a great point. All
Yeah.
of these individuals, look what they witnessed, and who did they call? They called the police
Right.
on the
Right.
place.
Yeah, calling the police on the police was definitely a theme that came back over and over again. We're going to be looking at more of those themes, more of the testimony in this case, more of the closings throughout the course of this afternoon. And we will let you know if there is a single question. We are still keeping an eye on that courtroom. So stay tuned. We're going to take a quick break.